employment savings account and not on the issue of remittance of employees' deduction by employer as alleged by the claimant in the present case. I totally agree with the submission of learned counsel for the claimant that the pension fund administrator is not a necessary party since the claimant has no dispute against it, and I so hold. Perhaps I should restate the settled position of the law on non-joinder or misjoinder of parties. Non-joinder or misjoinder of a party does not necessarily defeat a suit. See Order 13 Rules 14, 1, 2, and 3 of the rules of this honorable court, which empowers the court to, at any stage of the proceedings and on such just terms, order that the name of any party or parties improperly joined be struck out, or the name of any party or parties who ought to have been joined to be added, whether as claimants or defendants. In such circumstances, as the learned defendant's counsel had urged the court, an order of striking out and or dismissal will be inappropriate. Having affirmed that the claimant has locus to institute the action, I hold that the claimant is competent in law and on the basis of the facts averred in the statement of facts filed to support the complaint to have instituted the suit. In the same vein, this court is equally competent in law to exercise jurisdiction to entertain the suit. And therefore hold the defendant's objection is clearly unmeritorious, and it is hereby accordingly overruled and dismissed. A cost of 50,000 naira is awarded against the defendants. That is the ruling of the court. Yes.
Yes, number 2.
Yes, I have to give a date. Is Mr. Ajibo? Your case will be adjourned to the 23rd of May. Is it convenient? Is the 23rd of May convenient, learned counsel? Kaduna Division, your network is frozen. I guess they're trying to reconnect. Let's just give them a few minutes to reconnect.
Yeah.
I was asking Mr. Ajibo whether the 23rd of May, 2022 is convenient for the hearing. Is it convenient, sir? I think your device is muted. Can you unmute, please?
23rd of May is convenient, my lord. Very sorry, my lord.
Thank you, thank you. Case is adjourned to 23rd of May, 2022 for hearing. Hearing notice shall be issued and served on the claimant.
Okay, he joined.
Yes, the next case.
Case number 2, NICN/KD/05/2017 between Ehilebu E Indubisi and 39 others and Peugeot Automobile Nigeria Limited. My lord, parties absent.
Appearances, please, sir. Mr. Agu, your device is muted. Can you unmute?
Hello?
Yes.
My name is C.T. Agu.
Yes.
I appear for all the claimants.
Yes.
With profound respect to me, Lord,
Yes.
LJ Lagan, I appear with MC or her age you go for the defendant.
Yes. Yes, Mr. Lagan.
Mr. Lagan,
Okay.
go on.
Okay, my lord, the matter comes up for adoption. We are ready. Our written addresses have been filed.
We're also ready.
The defendant's final written address is dated and filed 23rd day of December, 2021.
Was filed on what date?
23rd December, 23.
Yeah,
12,
2021, yes.
2021. The Lord, upon receipt of the claimant's address, we file a reply on points of law on 14th February 2022, dated the said day.
On what date?
14th of February 2022.
Yes.
My Lord, we most humbly adopt the written address and the reply on points of law
Yes.
as our submission in this matter.
Yes.
We ought, my Lord, to dismiss the claimant's claims with substantial cause and grant the defendant's counterclaim.
Thank you.
Purpose of
Yes.
My Lord, on our part, we find out the plaintiff final written address, which is dated 28 January 2022, on the same day. It's filed on the same day.
On January?
28 January 2022.
Yes.
My Lord, we adopt same
Yes.
and urge the court to grant all the claimants reliefs while dismissing the defendant counterclaims. My lord,
Yes, sir.
my lord, I want to make further submissions.
Yes.
My lord, in the course of the hearing of this matter, the claimant discovered that the 32nd, 34th, and 36th, and 39 claimant has gone to settle with the defendants. We discovered that the 32nd, the 36th, and 39 claimants have gone and settled with the defendant while the suit was going on.
Sorry, you have to go over the numbers of the claimants. 32nd.
32nd, 34, 36,
Yes.
and 39.
36 and 39.
Yes, my lord.
Had
settled with the defendant.
Yes.
Accordingly, we apply that the said claimant's name is struck out among the claimants. My lord, we have taken care of their claims in the course of our address. We have highlighted their claim in the course of our address, and we have also withdrawn them.
Thank you.
My lord, I still have more to say.
Yes.
My lord, in paragraph 4.9 of the claimant's address, we submitted that
yes,
the argument of the defendant in this matter amount to approbating and reprobating.
Yes.
My lord, on this, we refer, my lord, to the case of Ade.
Is in your written address, sir?
No, sir. No, sir. It's
okay.
Additional authority.
Okay, thank you. What case is that?
Ade Osun, Adeosun.
Yes.
Versus Governor Ekiti State.
Yes.
Reported in 2012.
Yes.
One SCNJ.
Yes.
Page 260 at 282.
Yes.
And Mezu, MEZU, another case.
Yes.
Versus Cooperative.
Yes.
Reported in 2012, 7 SCNJ.
Yes.
Page 593 at pages 616 and 618.
Yes.
My lord, also in paragraph 4.13 and 4.17. 4.13 and 4.17.
Yes.
Of the claimant address, we argue that the lockout of the claimant by the defendant on 30/11/2010, on 30/11/2010,
yes,
amount to self-help.
Yes.
We further also submitted that self-help is not allowed in Nigerian legal system.
Yes.
My lord, we refer to Union Bank. We have a refer to Union Bank of Nigeria versus Alhaji Adams.
Yes.
Ajebule, Ajebule, and another.
Yes.
2011, my lord.
Yes.
12 SNJ.
Yes.
331 and 334 to 345.
Yes.
My Lord, we submit that the submission of the defendant counsel that the 67 workers locked out by the defendant in November 2010,
That the what?
that the defendant, we submit that the 67 workers locked out by the defendant in November 2010.
Yes.
We are among the 921 workers of the defendant officially terminated. We are among the 921 workers of the defendant officially terminated by letter of termination in 2007 is aimed at misleading the court. Is aimed at misleading the court.
Yes.
My Lord, also the submission that the letter of termination of the claimant tendered in this suit as exhibit DF1 to DF40 and DG1
As exhibits what?
as exhibits DF1 to DF40,
DF1.
DF1 to DF40,
Yes.
and DG1 to DG15.
Yes.
We are the crops of the defendant defense. We are the crops of the defendant defense.
Yes.
In trade dispute number IAP stroke HP stroke 5839
IAP stroke.
HB
Yes. Yes.
stroke 5839
Yes.
stroke 2011
Yes.
and appeal suit number NICN
Yes.
/ABJ
Yes.
/106
Yes.
/2011
Yes.
is also misleading.
Yes.
We submit that exhibit C2, CF2, exhibit CF2
Yes.
in paragraph 1 shows clearly
Yes.
the termination of 961 workers in 2007.
Yes.
By letter of termination.
Yes.
And another termination of the interim executive committee of the Steel and Engineering Workers Union of Nigeria.
Yes.
Where termination letters were mentioned are completely different from the content of paragraph 3. From the content of paragraph 3.
My Lord, I don't know whether he is arguing his address.
I've finished. It's just the last
The
sentence.
termination letter are completely what?
Completely different from the content of paragraph 3. Paragraph 3 of exhibit CF2.
Yes.
Which dealt with only 67 workers locked out on 26 November 2010 by the defendant. Which dealt with only 67 workers locked out on 26 November 2010 by the defendant.
Yes.
I'm not well obliged, but I'm most obliged.
Thank you.
Thank you for giving us this opportunity to say this.
Yes, Mr. Lagan.
My Lord,
Yes, what's your reaction to having the names of the 32nd, 34th, 36th, and 37th claimants struck out?
We don't have objection to that, only to mention. Milord, only to mention that the reasons given are not to our knowledge, or are not true, that the sex claimants are going to settle with the defendants.
So what was the reason that you are aware of? What is the reason that you are aware of? Because he said he stated this reason in his written address.
Yes, I did
He
it.
said they were going to settle. We said no. They went to collect their letters of termination, which they had earlier rejected when they were giving to them. That was all they did. There's nothing like settlement.
Sorry, I missed that. They just did what?
This set of claimants are among those who went back to the defendant to collect their letters of termination.
Okay, all they did was to collect their letters of termination of appointment.
Exactly. There was nothing like settlement. They just went back to collect letters that they had earlier rejected. When those letters were met out, as we have cleared it out in our pleadings, all of them were rowdy. They collected and threw them away and were doing all sorts of things. But later on, when some of them, many of them, apart from the ones he mentioned, went back to the defendant and pleaded that we want to collect our letters now. That's all that happened. There's nothing like settlement.
Okay.
In any case, you said you are not objecting to their names being struck out.
If you want to move their name,
yeah, I've noted your observation, but I'm just saying that you are not objecting to their names being struck out.
Yes. Let it, but it will affect his case one way or the other, and
Very well.
That is left for him.
Fourth application granted. The names of the 32nd, 34th, 36th, and 39th claimants are hereby accordingly struck out. Court cases adjourned to the 6th of July, 2020. Oh, it can be 6th, excuse me. Today is 5th. The 4th of July, 2022 for judgment.
As the
my Lord is convenient.
Need to be convenient. July 4th.
Judgment is reserved till the 4th of July, 2022. Yes, the court will. Thank you. This is the situation we find ourselves. Just bear with us for this period. We're praying that the situation will be improved in the country and we'll all be able to go about our businesses.
Very well.
Yes. Yes.
We commend my Lord for taking this step to have us heard and all of that.
Thank you. The court will rise.
I forgot that I've been caught.
I've got it nice.
Where is my